Hello, CGS3095. My name is David Barcenas, and today I'll be doing a short presentation focusing on privacy in the digital age, the issues surrounding it, and legislation that helps to protect it. To begin, I will talk about online privacy. So, in our evolving technological world, the internet has become a gateway for information, everyday communication, and unfortunately, extensive online surveillance. Consumers are becoming victims of massive electronic data mining and breaches, and in response to these issues, several countries around the world have created legislation that aims to protect user privacy. So, what exactly is online privacy? Online privacy is the level of privacy one has when connected to internet services. It covers the amount of online security available for personal and financial data, communications, and other sensitive information. Every day, users are giving up their data more and more, and that makes it harder for them to conceal their identity and not become a target of internet surveillance. Additionally, every company handles privacy differently. Because companies collect so much data, it becomes impossible to process using traditional methods. This data is called big data. In fact, a study done by the Pew Research Center in 2019 found that 81% of American adults believe they have little to no control over the collection of their data by companies. The top companies in the world, such as Amazon, Facebook, Google, etc., all capitalize off of big data. And additionally, breakthroughs in technology have made it easier and cheaper to record data. A user may visit a website and leave a digital trace behind unbeknownst to them, or they may have their data shared with dozens of other companies unwillingly. In either cases, it may be even difficult to figure out which companies are collecting data and how much of it is being stored. As the number of users increases daily, these privacy issues become less obvious, and users grow accustomed to giving up their privacy without knowing the true dangers of it. One of the major problems that are affecting online privacy today is called data mining. So, data mining is the collection of user information through tracking services and automated computer systems. Companies use data mining to learn more about user interests and personal information. For example, the data that thousands of technology companies collect allows them to look into what their users are interested in, what they are purchasing, the websites they can visit, or other personal information. This data becomes invaluable to companies because it allows them to cater the websites to their users' needs using targeted content. One of the main problems with data mining is that there's no limit. A study done by online learning company EduCBA found that an estimated 5,200 gigabytes of data um, exist for every person in the world. And this large collection of data means big business opportunities for companies. Companies can actually do a lot of things with your data. As I said in the previous slide, the more data a company collects, the bigger business opportunities they may have. Many companies gather large data set and they use it to target advertisements to specific users, or they sell it to data brokers. Buyers of this data are also able to access a great amount of information about potential customers, and this allows them to create a profile for each user. Some companies might not even sell the information. They may just share their data without many of their users knowing. The Warren School of Business noticed that PayPal shares user data such as bank information, recent purchases, location data, and other private information with hundreds of other companies around the world. In many cases, there's no easy way to opt out of this type of sharing, and this makes user anonymity harder to preserve. Another major issue affecting online privacy are data breaches. So, with a large collection of data, like through data mining, comes the risk of data breaches that affect hundreds of millions of people. According to CSO Online, an online publication board based around IT security, the two biggest data breaches in history saw 3.5 billion people having personal data such as banking information, medical records, passwords, and social security numbers stolen. Data breaches happen every day, unfortunately, and every company is susceptible to a breach. And cyber criminals are always developing new ways to access consumer data, so that makes it impossible for a company to 100% secure all of the user data, making this problem very difficult to solve. Companies take many preventive measures to help protect against data breaches. In general, companies will limit who is able to access customer data to only a few selected individuals and only if they specifically need it. For example, a customer service representative might have more access to customer data than another employee in the company. Employees are also trained all the time to help protect privacy and handle different data situations. Companies are also required by the FTC to ensure the protection of customer data using advanced security systems. Some companies will even invest in data breach insurance to help protect against financial loss. The average cost per person affected by a data breach is $148. As a result, companies use data breach insurance to safeguard against the thousands of dollars a large data breach could cost. One of the main controversies of big data or collecting data is whether it's ethical or not. So, under utilitarianism, it's agreed that some actions may be considered right or just if it results in the overall satisfaction of a group of people. In the context of online privacy, some may argue that the large-scale collection of data can positively benefit society and has some pros. For example, big data can be used by law enforcement to help investigate crimes and improve national security. An institution like the CDC could track user health records to understand how to handle diseases and improve public health. Another pro is that big data has also been used by companies to improve overall customer experiences and incite technological progress. In all of these cases, some privacy was given up to improve the overall quality of life of citizens. But at the same time, data can be misused to cause harm or be leaked, as we saw through data mining and data breaches. It is a society's duty to consider the two sides of data privacy and determine what is a good balance between overall satisfaction and the least possible harm for all of its citizens. To help combat the issues of online privacy, the United States created an extensive list of laws and regulations. While there is no single federal law that focuses directly on data privacy, a number of other laws have been established that focus on managing user data. The FTC is one of the institutions set up to help protect online consumer privacy through enforcement actions. For example, the FTC is in charge of protecting user privacy through their stance against fraudulent actions. They make sure that companies follow their own privacy policies, and companies that fail to protect their consumers will have action taken against them in the form of investigations, lawsuits, and fines. One specific federal law that helps to protect user privacy at the federal level is the Children's Online Privacy Protection Act, also known as COPPA. COPPA prevents the collection of any child's information under the age of 13 without the consent of a parent or legal guardian. Companies must follow the FTC guidelines for COPPA, and they must have a written privacy policy explaining what is done with the collected data, and they must have the data readily available when a parent requests to see it. The current penalty for non-compliance with COPPA is around $43,280 per privacy violation per child. Like I said in the previous slide, the United States federal government has not created many federal laws that help protect against the issues of online privacy. Instead, it gives the states these rights. Two states that created these laws were California and New York. So California created the CCPA, which is a state law that defines how businesses must handle the data of California residents. For example, the CCPA gives Californians the right to access the data at any time and learn who it was shared with. Additionally, they may also sue companies if they fail to secure user data in a data breach. The CCPA currently affects all businesses with $25 million in gross income or that serve 50,000 California residents, and the current fine per violation of the CCPA is $7,500. The New York Shield Act is another law that's similar to the CCPA in that it protects New York residents. It also defines what's considered private data, and it's an extension of another New York law. That's one of the main differences. Companies must notify New York officers in case of a data breach, and while other states only notify customers if their data was stolen, the Shield Act notifies customers even if their data was only accessed by an outside entity. Another key difference between both laws is that the Shield Act does not directly give consumers the right to sue companies for data mistreatment. Other regions around the world have created their own laws and regulations that help to protect data privacy. The most famous of them all is the GDPR, or the General Data Protection Regulation. Similarly to the CCPA and the Shield Act, the regulation applies to all companies that attract European consumers, regardless of where the company is based or who their main targets are. Additionally, consumers also have the right to agree with their data being collected, know what it's going to be used for, and be notified in the case of a data breach. In comparison to the EU, the United States decided on a much different approach to privacy law creation. In the United States, there's no such federal law that is considered equivalent to the GDPR. Instead, the United States gave these rights to the states. This leads to different rules and interpretations of data safety on a state-to-state basis. On the other hand, the EU focused on establishing a supranational law that sets data privacy as a strict priority. Brazil passed its own data privacy law called the LGPD. And unlike the GDPR and US laws like the CCPA, all companies in Brazil must abide by this law. They also define what is considered to be personal information, and they require every company to have a data protection officer. The fines for a violation are smaller compared to the GDPR. The maximum could be 2% of a company's max revenue versus the 4% of a company's max revenue in the GDPR. In conclusion, we learned of the pros and cons of big data, but the question of how best to preserve online privacy remains unanswered. Most of society is unaware of the grave dangers of big data and the risks it poses to their security. While several laws have been implemented in the United States and other countries around the world, it becomes evident that no single law can fully protect users from leaving an unintentional digital footprint. Overall, the public, online companies, and every government must work together to uphold the online privacy protection of citizens and preserve data safety.